So it's 3 years since the introduction of the personal injury guidelines now, and we've had the landmark decision from the Supreme Court dealing with the constitutionality of the guidelines. We've also had the benefit of some really interesting judgments from the High Court and the Court of Appeal. So maybe we'll start off with you giving us a brief background in relation to the case of Bridget Delaney.
Yeah, I mean, that's a really interesting decision by the Supreme Court. It challenged the very constitutional foundations of the guidelines. And it also challenged how PIAB assessed the guidelines in particular circumstances. Briefly, by way of background, Miss Delaney fell over on a pothole or slipped on a pothole in Waterford. She suffered a non-displaced fracture to her ankle. This was around May 2019. She made an application to PIAB June 2019, but this wasn't assessed until May 2021. As we know, the guidelines came into force in April 2021. All of this resulted in her injuries being assessed under the guidelines and not the old book of quantum. Under the guidelines, her injury was assessed at €3,000, and if it had been assessed 6 weeks earlier under the book of quantum, she would have gotten somewhere between 18 to €34,000. I mean, clearly she wasn't happy with this decision. She brought a judicial review of the PIAB assessment. This wasn't upheld by the High Court and it moved on to the Supreme Court. I mean, 7 judges heard the case in the Supreme Court. There were 5 different decisions. I mean, this could have knocked the foundation of the guidelines. Would you talk us through, in a nutshell, what all these decisions said and where we are right now?
Yeah, so I've read the judgments, and the the appeal came down to two main points. Her first ground of appeal was to do with the constitutionality of how the guidelines were adopted. And the second ground of appeal was to do with, whether or not her claim should have actually been assessed under the older regime of the Book of Quantum as opposed to the personal injury guidelines. Now, in relation to the first point around the unconstitutionality of the guidelines, the Supreme Court said that, yeah, actually, the particular section of the Act that provided for the adoption of the guidelines was actually unconstitutional. But the Supreme Court went on to clarify that by a subsequent act of the Oireachtas, this unconstitutionality was cured. So essentially, that just means that the guidelines are here to stay and they are constitutional. In relation to the second point, then the Supreme Court said, nobody has a vested right in having their claim assessed under any particular regime. So she wasn't entitled to have her claim assessed under the Book of Quantum. So the PIAB assessment of €3,000 stands.
Well, that's interesting. So, kind of in a nutshell, the Judicial Council part of drafting and developing the guidelines was found to be unconstitutional, uh, crossover of the separation of powers. But by the Oireachtas enacting it in the legislation, that cured that defect, that constitutional defect. I mean, it's 3 years down the line since they've been enacted. They're due to be reviewed now. In light of what will this review look like? Do you think now, considering the Delaney decision?
Yeah, it's very difficult to say, obviously, because, of the unconstitutionality of the particular section. It could cause some issues and may require some legislative amendment. Minister McEntee has said that they're looking at this and any necessary legislative amendments will be made. So it remains to be seen, I suppose, when and how the review will take place, but it's something we're definitely keeping an eye on.
Well, and okay, a second really big question for you, I suppose, is what will the review look at? What do you think could be changed in the guidelines now? We've seen them around for the last 3 years.
Yeah, I suppose since this is the first review, it's very difficult to say what it will look like. Um, it's likely they'll look at the level of injuries in the various different brackets, be it upwards or downwards review of the quantum. They might also look at introducing other injuries that aren't actually dealt with under the guidelines. What I don't see the review doing is providing for any additional directions for the courts. I don't think they'll want to interfere with judicial discretion, so I think they'll steer clear of that. And just to focus for a minute on the judicial application of the guidelines, I know there's been some very interesting cases, and you've looked at one in particular that was delivered recently.
Yeah, I looked at the Court of Appeal decision in Coughlin. I think that's a really interesting case for a number of reasons. I mean, at kind of at a micro level, it looked at the assessment of serious or moderate shoulder injury. On a broader concept, we looked at some of the principles that should and shouldn't be applied when assessing injuries under the guidelines. The plaintiff, by way of background, was driving home to Howth. His car was struck by a truck. He suffered soft tissue injuries to his shoulder, to his wrist, to his neck, and he complained of these persistent headaches. The medical evidence in relation to the shoulder said that if he received a number of injections and these didn't cure his symptoms, he'd probably have to undergo surgery. The High Court, in assessing this, said, look, the requirement to undergo surgery and the persistent pain in the future meant this was a serious shoulder injury valued at 40 to 75,000 euros. And ultimately, they awarded at the top end at 75,000 euros for the soft tissue shoulder injury. The Court of Appeal looked at the medical evidence and essentially pointed out that he'd received one injection, one episode of physiotherapy, and hadn't gone for any follow-up with his consulting surgeon. Therefore, they said, like, the probability of surgery was remote. It didn't fit in at this serious shoulder injury, which is really reserved for dislocated shoulders and fractured shoulders. And it said it was more kind of somewhere between moderate and a serious injury. And we see this all the time. Injuries don't fit neatly into one category or the other. It ultimately awarded 40,000 euros for the shoulder injury.
And what was the court saying then about the other soft tissue injuries?
Yeah, in assessing the damage, it actually described the shoulder and the headaches as both being dominant injuries. These persistent headaches going on for 3 years was described as the dominant injuries. It was categorized as mild brain damage under the guidelines, and he was awarded 30,000 euros for this. This is ultimately reduced down under the principles of proportionality, and the total for the secondary injuries was 15,000 euros. When the Court of Appeal looked at this, they didn't have an issue with the award of 15,000 euros as secondary injuries, but they were quite critical of the methodology. They said you can't have two dominant injuries. You have one dominant injury and then you assess the secondary injuries. So it's very critical of that approach taken by the High Court, and which is interesting. It also said that headaches do not equate to brain damage. And we can see in the guidelines that there's no category of damages for this. We see it quite a lot in cases, this concept of persistent headaches after an accident. They need to be linked to some other injury.
That's really interesting about the dominant injuries. What I know they were saying something about expert witnesses as well in that judgment.
You're right, Laura. There were a couple of interesting decisions on expert evidence. We've seen some commentary last year from the courts on this. Firstly, the Court of Appeal was quite complimentary or supportive of agreeing medical reports in advance of a hearing. It said this expedites litigation. It saves doctors from hanging around in court. It's quite a cost-effective way of dealing with it. In terms of conflicts in the report, it said, I mean, the court doesn't have to accept the medical report at face value. It can look behind the report, even if this isn't challenged in court. I mean, where there is a conflict in evidence, it's always better for this to be teased out in oral evidence. But where that's not practicable or where that's not possible, the Court of Appeal said that's okay. They can look behind the reports, which is interesting. The Court of Appeal was also quite critical of the neurosurgeon who delivered a report in this case. Firstly, there are a number of factual inaccuracies in the neurosurgeon's report. It described the plaintiff as working and returning to work when it was accepted. He hadn't worked for a number of years. On the medical side, the neurosurgeon diagnosed soft tissue injuries with the plaintiff's neck. And the level of injuries was contrary to what the two orthopedic surgeons in the case had diagnosed. And the Court of Appeal said, like, the neurosurgeon in a medical sense was stepping outside his area of expertise and would prefer the evidence of orthopedic surgeons in relation to the neck injuries. I think the factual inaccuracies in his report kind of undermine some of the medical evidence, which is quite interesting.
Yeah. And I know at the centre of that judgment as well was the idea of proportionality. I know the court relied on the case from the Court of Appeal last year, late last year, Agnieszka Zagancic. And at the heart of that decision was the concept of proportionality, which is that similar injuries attract similar awards, and the cap on general damages of 550,000 euros needs to be borne in mind by the court when making an award. And I think we're seeing over and over again that in these judgments applying the guidelines, they are referring to the concept of proportionality, and that should provide some consistency in cases going forward.
Yeah, I mean, the concept of proportionality has been around long before the guidelines. It is interesting seeing how it's been applied now with the guidelines in force. I think going forward now for the rest of this year, we'll be interesting to see what shape any review of the guidelines takes 3 years down the track. I think the decision in Delaney does provide some roadmap of what a review of the guidelines should take and some guidance how to avoid any constitutional potholes.
Thanks, Richard.
Thanks, Laura.